Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to today's session of the Massachusetts Appeals Court. It is January 7th, 2022, and the first case on our docket this morning is number 21P0514, Boston Clearwater Company, LLC versus Linfield Conservation Commission. Counsel, when you're ready, you may proceed.
Good morning. May it please the court. Richard Nyland on behalf of Boston Clearwater. We're here today to overturn an enforcement order issued by the Appalachia Linfield Conservation Commission for replacing a sitting bench within the no disturb area on our property, and for placing a religious cross on a hillside also on our property, not in the no disturb area. 35 years ago, in the case cited Bourne v. Austin, it's been held that an individual who wants to take an activity or perform an activity within the jurisdiction of the Conservation Commission does not have to file a permit request if they do not involve themselves in dredging, filling, removing, or altering a resource area. It's our contention that the record clearly shows that placing a replacement sitting bench 15 feet away from a wetland and placing the cross at the top of the hill was not involving dredging, filling, removing, or altering a wetland resource area. There's no evidence in the record that includes a transcript from the Conservation Commission meetings and pictures of any alteration of any wetland resource area as a result of the two activities.
So, counsel, you say no evidence. I mean, the record indicates that a machine was used of some sort to move the cross up the hill, and that as a result, there was some displacement of soil along the path, right?
Well, it's interesting, Your Honor. There's no evidence of any machine being seen by anyone on the property. That was speculation in terms of the machine. Clearly, the cross was large enough that when it was brought up the hill, some of the soil was disturbed, as if you're raking an area.
You say it's speculation, but I mean, there are statements in the record to the effect that I can't remember what they called the machine. It was some
a skidder, Your Honor.
So what separates speculation from evidence under the circumstances? Because we have these statements that are made in the record. Now, I understand no one actually observed it. I agree with you about that. They did observe the area. The standard of review is what the standard of review is in the Hingham Conservation Commission case. How do we decide that that's insufficient?
Yeah, we agree on the Garrity case. It's an arbitrary and capricious standard, what I think we call the reasonable person standard. Common sense. Is there anything that supports their position? Interestingly, there was a complaint that came in from the neighborhood that there was activity that was taking place. The Conservation Commission chairman and a newly appointed inspector went to the site. They didn't see any equipment there. They alleged that there was a path that was created and that there were trees that were removed and that their benches had been installed. So there wasn't any evidence of any heavy equipment around for all of this alleged work that had taken place. So I think when one's looking at that reasonable man's test, the question is, what evidence was there on the record, pictorial or otherwise, that supports any activity that was in violation of the Wetlands Act or the bylaw?
Would it be a violation of the Wetlands Act to clear a path in the buffer zone, for example, by moving large branches and putting them aside, even if dead? Would that be something that could not be done within the buffer zone? Would that be an alteration?
Yeah, I would say you're on everything except for the tree branches in the buffer zone, because you are allowed to prune tree branches. But yes, if you were going to clear an area, it's dredge, fill, remove, or alter. So if one was going to clear an area and build a path, yes, I would say you would have to file with the Conservation Commission before you could conduct that activity. But that's not what took place here.
Well, I mean, so you say that, but I mean, I look at the photographs, and granted, the photographs are very hard for us to divine on a pellet record. And that, honestly, that I'm not sure whose problem that is, because there's a burden of proof issue, it seems to me. But it appears that there's some sort of path that goes through the woods toward this, where the cross is placed, and that branches, at least dead branches, are sitting off to the side of that path as if they've been moved in order to allow people to traverse it. Not enough?
Yeah, well, a couple of things, Your Honor, because I think we're at the heart of the matter. This is a forested area, and there clearly are areas in between the trees. There's an allegation in the report by the Linfield Conservation Commission. There was a removal of trees. However, our engineer had incidentally put together a plan that showed the location of all the trees on the site before this took place for another reason. So then when we showed them this plan of all the trees, guess what? All of those trees were remaining. There was a picture of one tree, Your Honor, that we presented ourselves, it's part of our record, that had been felled years ago and had never been picked up because it's from the adjacent property, and it's right near the cross. You can see it's split. And the record shows that wasn't our responsibility. So our view is that the cross was put in a clearing. There weren't any trees.
There's statements made by the inspector to the effect that he went around the time when he went to inspect in, I guess it was June maybe. He saw trees down with some withering of the leaves, and that he went back in October and the leaves were brown. And what I took from that was that the trees that he saw in, am I right? It's June?
Yes, you're right. It's June and
October. Trees he saw
yeah.
down in June were recently downed.
Yeah. Well, again, there was one sapling that we've agreed in a 3-inch sapling that went down, but the other material that was off to the side was not associated with what was taking place. You can see
was not associated with what was taking place in June in the moving of the cross.
Correct. And there was no other reason for any activity up there, but you can see on
whoa, that part doesn't follow. I mean, and what's on my mind is whether there's evidence. If he says, I see evidence of trees recently felled because I can tell the leaves are withering. They weren't felled the day before, obviously, because the leaves are already withering. But isn't that an indication of work that had been done in the buffer zone?
Well, that wasn't work associated with bringing
the moving of the cross.
Yeah, and there wasn't any work that was taking place up there. This is a forested area that we have no reason to perform any work up there other than to bring up the cross. So yeah, this was a DPW inspector who was appointed and went on the site. And I don't know what he could say was there before, because as I said, this is an area that is cleared and all trees are still there. There weren't any trees that were shown from the plan to have been removed.
Mr. Nyland, let me ask you a big picture question. I understand that you have a difference of agreement about the weight of the evidence, or perhaps whether or not there even was evidence. But assuming that we conclude that there was some evidence, it sounds to me like what you're asking us to do is weigh that evidence differently than the Conservation Commission did. And my question is that our role?
Well, I think the answer is no. I don't believe that that's your role. I think if you're to determine whether or not they were acting arbitrarily and capriciously. I believe that their actions show that they were acting arbitrarily and capriciously, and that the record shows that they were acting arbitrarily and capriciously. The Fieldstone case takes a look in terms of determining ad hoc agenda. They look at two things. Is there an ad hoc agenda, number one? And number two, are there facts in the record to show, to support their position? Because we do agree that once they issued the enforcement order, I believe that the burden shifts back to us to show that there wasn't a violation. There's a colloquy between myself and a member of the Conservation Commission early on in July at the first meeting, when he says, "Mr. Nyland, this is a serious violator." I mean, he was the commission seemed to be more concerned about my client than they were in terms of what took place there. So I believe that there was an ad hoc agenda. Second, in terms of what's in the record.
Help me with this. So I can agree with some of your sentiment. But how do we determine, how would we go about determining on appeal that there's an ad hoc agenda? Was that the argument that was presented to the Superior Court judge? And if so, how did you prove it?
I think, as I indicated, I think there are at least two reasons. Number one, because of the statement from the Conservation Commission member at the night the enforcement order was being issued, was that this was an issue with my client and him being a violator, not having anything to do with bringing a cross out there that day or putting a replacement bench there.
But there are many different statements made by different members of the commission on that day, and some of them quite appropriately said, "I'm only interested in whether this is going to cause a potential for erosion into the wetland area." So, I mean, how are we on appeal? I don't think there's a finding by the Superior Court judge with respect to this. In fact, he doesn't take evidence, right? It's like a 30A appeal in the sense that it's not, but it's like that in the sense he just looks at the administrative record.
That's
so
right.
So you're saying it's sort of a de novo review? We can conclude that it is ad hoc because it's de novo for us?
Well, I think as I said, the first is their agenda. The second is the absence of the facts in the pictorial record. There's nothing that supports a position that there was any alteration of any wetland. And I pointed out to.
Well, it's not an alteration of the wetland. It's an alteration within the buffer zone, right?
That's correct.
But so is moving dirt around? Is that an alteration within the buffer zone?
To me, it's not the way that the regulation states it's the alteration. The disturbance has to result in an alteration, which impacts ultimately the wetland. So if I'm playing golf,
how am I gonna? Oh, stop. That's really important. Okay, you have a view that the alteration has to be something that impacts the wetland, and my question is, where do I get that from?
Well, if you take a look at the regulations and the bylaw, it says no person shall remove, dredge, build upon, discharge, or otherwise alter a resource area without a permit. And there's no evidence.
A resource area includes a buffer zone, yes?
That's correct. And we're arguing that there's no alteration of the buffer zone. Because when you take a look at the definition of alteration, it's not just moving dirt. As I said, if you're playing golf next to a pond and you swing and you create a divot, that's not an alteration.
Well, where's the definition of alteration? It's going to tell me that moving dirt is not, I mean, digging is, right?
Well, digging or removing, removing, excavating, dredging, yes, absolutely. But that's not what took place here.
Moving dirt, sort of piling it up on one side, creating ruts, that's not?
Absolutely would be, yes, sure. But that's not what happened here, Your Honor. That's not what happened. I agree. Yeah, excavation,
Well, but
dredging.
you've got in the record, you got an indication that root balls were exposed by moving this cross up the hill. So how do we decide that exposing a root ball is not, but digging or excavation is?
I think you're on. That's why we have a difference of opinion in terms of the facts. There is an allegation that their root balls were exposed. There is no evidence presented, and the evidence was presented from us was
If
to the
someone says,
contrary.
I went up the hill and I saw the day after this happened, root balls were exposed, that's not evidence?
That's
I
not,
observed it with my own eyes.
yeah. If that's the case, there's no nexus between moving the cross and exposing the root ball, Your Honor. I see my time has expired, so I will rest on my papers.
All right, let me just see if there are any questions from either of my colleagues.
I did actually have, I did have one other question. What do we do with the fact that there was a request made? There were 4 elements of what you were asked to do. And do you think those elements are unreasonable?
Yeah, well, I didn't think they were appropriate because they weren't tied to what took place on the property. We were very diligent.
Well, they certainly would have been tied to it had there been scraping of the ground such that there could have been erosion. They said, put some mulch down and put a couple of, erosion controls in. Why did your client not do that?
I think the record shows, so what we did is we went out every time it rained and we committed to them if there was any instance of any possible erosion, we would do that immediately.
Deciding what to do. Why not do what you were asked to do? I mean, we're here, this is at least the 3rd time that I've seen your client and the Linfield Conservation Commission before the appeals court, right? And the request was to do 4 things, one of which was throw some mulch down. Why not do it?
Well, the reason for the mulch was because they alleged that we moved the understory around, that the forest litter was moved. We originally, actually, Your Honor, agreed to put mulch down, but when we determined at a later point that there was no alteration, that's when we said, we will put things down when it's necessary. And we were very diligent about that. We did go out and we saw that there weren't any impacts. And I will tell you, there's nothing in the record that suggests that any erosion or anything ever took place.
All right, thank you, Mr. Nyland. Mr. Mullen, the floor is yours when you're ready.
May it please the court, my name is Tom Mullen and I'm the town council for the town of Linfield. Let me get right to the issue of whether there was any kind of violation here. I think it's absolutely clear that there were at least some violations. It's clear that 2 big, heavy granite benches were placed within 25 feet from the wetland.
So the Linfield Conservation Commission is coming before the appeals court and arguing that the basis for the affirmance of the enforcement order is the placement of 2 benches. Is that right? That's your argument?
No, that's part of the argument, Your Honor.
Okay, but that's one of the arguments, right? In fact, it's the principle, it's the first argument you make in your brief. Is that right?
It is, yeah.
Okay, how about the fact that you're on July 16th, the chairman of your commission said they are not the reason for the enforcement order, quote unquote.
Yeah, what he meant in context.
No, that's what he said. It's not what he meant. He said that. How could anyone read that other than I am not grounding this enforcement order on the placement of the benches?
Well, he was concerned about the process that got the benches there. He believed, the whole commission believed, that it was impossible to move these big, heavy granite benches there without using heavy equipment that probably would have damaged very sensitive wetlands flora.
Was there any evidence of any of that next to the benches?
No.
The statements in the record are that the benches were moved by hand and placed by hand.
That's right. And ultimately, for that reason, the commission decided, as you say, it wasn't too concerned and those benches could stay.
Well, but are you grounding your argument now on the placement of the benches or not? It appears to me you made that argument to the Superior Court. You've made that argument to the Appeals Court. But I literally looked at the record and said, you said that's not the basis for your order.
The significance of the no disturb zone is you don't construct anything and you don't deposit any
I don't think you've
materials.
answered my question, sir.
It is part of my argument, Your Honor.
Okay, well, I have to tell you, this judge's reaction to that is, that sounds arbitrary and capricious to me. When you tell someone this is not the basis for our order, and then when you go to court, you ground your argument on something you have said is not the basis for your order, that strikes me as arbitrary.
Well, that is part, but it is by no means the whole. I think the more significant point is that the bylaw defines a resource area to include the buffer zone up to 100 feet from the wetlands. And one may not degrade or alter the resource area without permission. And the bylaw defines what degrade or alter means. It means you can't change the drainage patterns, the flow patterns, destroy plant life, or do anything that tends to pollute a body of water. Here, there's evidence that BCW destroyed trees. They scraped brush and understory from the hillside. The very hillside.
You say there's evidence that they destroyed trees.
Yep.
I saw evidence that they took over a 3-inch sapling and nothing else.
Well, they knocked down at least one tree, and a 3-inch sapling. Well, that means that it's 3 inches in caliper at breast height. So that's a fairly substantial plant.
So knocking over a 3-inch sapling is a ground for the Conservation Commission to issue an enforcement order and threaten fines of $300 a day.
It's the kind of thing that if you want to do, you go to the commission in advance and get permission. And the commission would probably issue you an order of conditions allowing you to do it, but requiring you to do various erosion controls of the very reasonable kind that they imposed retroactively through the enforcement order.
So anything within 100 feet of a wetland, including taking down a 3-inch sapling, you have to come before the Conservation Commission about. Anything within 100 feet. That's the position. That's your understanding of the law.
I'm telling you that the regulation says destroying plant life constitutes degrading or altering a resource area. And if you are
that's the way it's enforced, by the way, throughout the rest of Linfield, that you know, if it is destroying plant life include cutting the grass?
I frankly don't know whether cutting the grass would be.
Well, it sounds like destroying plant life. I mean, you know, the grass got cut, or pruning trees, which is specifically in your bylaw. I mean, is that the way the rest of people within 100 feet of a wetland are treated in the town of Linfield? That there's an enforcement order? Are there any other enforcement orders out there because someone pruned a tree within 100 feet of a wetland?
Well, the Conservation Commission is quite vigilant, and most people are not scofflaws about this. They come before the commission before they act rather than get dragged there after the fact.
I would be surprised if they come there because they want to cut their grass or whack the weeds around a structure that's been there for 120 years.
Well, if they want to use heavy equipment to drag some large heavy object up a virgin hillside, that is going to knock down trees and scrape up understory and expose roots and create the risk of erosion into an historic dell area that the town has actually gone to this court to litigate about in the past, they better go to the Conservation Commission in advance for permission rather than
what is
wait.
The evidence? What is the evidence that that they used heavy equipment?
Well, we don't have any witnesses for this, but I don't think that there has been any denial by BCW of the statement made at a commission meeting that it was apparently a skid steer or similar equipment that dragged the cross up the hill. And I think the evidence is the breadth.
What is a skid steer?
It's like a tractor, Your Honor, a small tractor.
Were there ruts? Were there any tire tracks? I didn't see that in the photographs. The photographs are taken the day after, didn't indicate anything that I could look at with an untrained eye, recognizing that it's not that easy to look at a photograph and see evidence that heavy machinery had been going up that area.
I think the evidence, Your Honor, was that a fairly broad area had been like scraped going up the hillside. And it was difficult to believe that through manpower alone, they got this heavy cross up the hill.
And if I look at those pictures again, am I going to see the scraping of the hillside?
I think you'll see some indication of it. It's difficult to catch in a photograph. But again, the chair and his field investigator went months after the fact in the presence of the owner, and it certainly looked to them as if the work that they had feared was done had been done, and this evidence of there was evidence that some plant life had been destroyed, and that plant life was useful for purposes of avoiding erosion into the wetlands below. So,
Mullen, can I ask you a sort of a different question related to a portion of your brief having to do with a claimed trespass?
Yep.
Assuming we were to find that in fact there was evidence of a trespass, what's the authority for the proposition that evidence gleaned during the course of a trespass is not admissible in a civil proceeding?
Yeah, I think the only argument that would support the exclusion of that evidence would be the Grant case. And the Grant case is just completely off base. It is a criminal action. There was a criminal prosecution. It was not a civil enforcement order matter. And in Grant, you had evidence that the commission member literally snuck onto a private contractor's yard. It did not appear that the yard was open to the public. He tried to do this and succeeded in doing it in secret and in defiance of an order by the owner to stay off the property. In fact, the owner had previously gone to the police to try to enlist their support, their help in keeping commission members out. Here, you have exactly the opposite. There's nothing in the record to indicate any kind of trespass. The commission had not been told to stay out. There were no signs saying no trespassing. To the contrary, this was an open air commercial site. The public is welcome there. It's a 2-acre wooded site. You have to walk or drive down a driveway to a couple of buildings at the bottom. One building is a locked pump house, and the other is open to the public for sale of water. You go there, you put money in a machine, and you fill up your bottle. All members of the public were welcome. The chair and his field investigator went there during regular business hours, broad daylight. They knocked on the door of this vending building to see if they could talk to anybody, but there was no one there. And they made observations that absolutely any member of the public was free to make.
Mr. Mullen, what I couldn't tell from the record what the amount of the accumulated fines are as of now.
I believe that at this point, we would have to go back at most 1 year because of the statute of limitations. See, my reading is that we have two alternatives that we could invoke. One would be a criminal process, a complaint to the district court, and that would entail a 1-year statute of limitations. And the other would be a non-criminal disposition, which would allow us to go back, I think, only 15 days, because you have to issue daily tickets and get them to the district court not later than 15 days after the oldest violation. So we would use the criminal process, presumably. We have not done it.
Which means, assuming it's a year, so you're talking about $300 a day for 365 days?
Yeah, I did the calculation. I think it comes to about $109,000. And
You know, neither one of you cited a case called Maroney against City of Haverhill, which I'm very familiar with and which has to do with civil fines, came down within the last couple of years. I think in general, you're right about the process. I'm not sure about, as Maroney itself says, about how far back you can go, but you have to issue them a ticket, that's for sure, if you're going to do a civil fine, and you haven't done that yet. You know, okay, I'm sorry, Judge Kinder, did you have more questions along these lines?
No, I think he's answered my question. Go ahead.
There's the question that's on my mind and that I've struggled with is where does the burden of proof lie here? So you have something before you, you have a record before you as to which your client makes a decision to issue an enforcement order. Presumably you have the burden to show that the enforcement order was not arbitrary and capricious, right?
Well, I think the burden is on the complainant, the plaintiff here, to show that it was arbitrary and capricious.
So here's the problem I have with that, because I'm struggling with it a little bit, and I'm struggling with it. If that's right, then I have trouble with the process that allows you guys to issue a civil enforcement order and say, if you don't comply with it, it's going to cost you $300 a day, which, by the way, I've seen in that Haverhill case, the fines were $1 million when they were actually, or 650,000 when they were finally imposed. Now that was overturned. Where you haven't met an initial burden of showing that there's been a violation. I mean, it seems to me, if you're going to ground civil fines, the burden, at least an initial burden of coming forward with sufficient evidence, has to fall with the commission.
Well, I think that would be a stronger case if here the BCW had not, through its counsel, agreed in writing to do all of the 4 things required by the enforcement order.
Why does that matter? I mean, where we are is you've issued an enforcement order. They say arbitrary and capricious. You say not arbitrary and capricious. And because it's not arbitrary and capricious, we can enforce that at $300 a day. And the burden of proof is on them to show that it was arbitrary. That's your position, right?
Yeah, I think that they do have to show that it was arbitrary and capricious.
I got to tell you that it doesn't sound like any process I'm familiar with where you can enforce it with very substantial fines and not have at least a burden of coming forward and showing that there was a violation.
Well, I think the significance of their agreeing to the terms of the enforcement order is that it would have been very easy for them to have complied. They wouldn't have agreed if it had not been doable. They ultimately just, I mean, they were accusing the commission of this ad hoc agenda, basically not liking them. But I think what's really at issue here is it's kind of the shoes on the other foot. Once the owner got involved, in October, he met with the chair of the commission and he said, no, I haven't done any of those 4 things and I won't. He made it a kind of manhood issue.
Well, if I could, I don't disagree with you with respect to the point that they could have done those 4 things. But I'm not sure how important it is to the decision we have to make. And in terms of ad hoc decision making, I was struck by this page 150, the transcript of one of the first 2 hearings where Chairman Martindale says, I mean, they can still sell water. And Janice Solomon says, too bad we couldn't stop that. Wouldn't that be fun? Says another member of the commission. I was struck by that. I have to tell you,
Well, ultimately,
That's beyond their jurisdiction, right? They're not able to shut down businesses, are they?
ultimately, commission, any board can speak only through its recorded votes. And the recorded votes of this commission were quite reasonable in the circumstances.
Understood. Thank you.
Thank you, Mr. Mullen. I see your time is up. I see no further questions to let us know when the case is formally live.
Thank you, Your Honor. We are live and on the record.
Good morning and welcome to today's session of the Massachusetts Appeals Court on January 7th of 2022. The next case is number 21E0343, Jessica Grigg and another versus Edmund R. Leclerc. Counsel, when you're ready, you may proceed.
Good morning. My name is Andrew A. Caffrey Jr., and I appear on behalf of Edmund Leclerc, the defendant and appellant in this matter. I appreciate that you're familiar with the facts in this case and the issues on appeal. In a nutshell, this case is a dispute over a failed agreement for the defendant Leclerc to sell his house to the plaintiff. In 2018, Leclerc had his house on the market for sale with his agents. His agents were contacted by the buyer's agents in early 2018, who said that she had parties who were interested in the property, but there was a critical factor. They needed to be able to be sure that they could raise their chickens on the property. Before even making an offer, the buyers requested certification that there were no covenants or restrictions prohibiting chickens on the property. Leclerc's attorney did a title search and issued a letter of opinion where he certified that there are no private restrictions for the land at 16B Laurel Hollow Road, which prohibit the keeping of chickens on the property.
Mr. Caffrey, let me interrupt you and ask you to leap forward to one of the issues that I think is critical in this case, and that is to have you explain to us why the use of the term property in section 27B or paragraph 27B of the purchase and sale agreement is ambiguous. It's not clear to me why it's ambiguous.
Well, property is something that you own that is exclusive to you. And the, as I've said, as the cases say that while what leads up to the agreement can't contradict it or overturn it, it can elucidate what the parties were thinking. And when the offer was made, the only property in question was the building lot at 16B Laurel Hollow Road.
But in making that argument, aren't you asking us to look beyond the terms of the contract to the context of the contract and what led up to it? And doesn't the law suggest that unless the term is ambiguous on its face, we look only to the objective meaning of the words in the contract?
Well, I guess to some extent I would agree with you, because I think the property in question is just lot 2, the 8.51 acre building lot. The property being bought was not lot 26, the undivided half interest. That needed to go along. That could have just been an easement as opposed to an ownership interest. And if it was an easement to use lot 26, that easement would have gone along also, but that is not the property.
I'm sorry, let me just finish this thought. I hear your argument on that point, but doesn't paragraph 2 of the same purchase and sale agreement describe exactly what the property or premises is? And it incorporates 2 different lots.
Well, I think that's a distinction. I think the premises are both the property and the undivided half interest. And I think my motion for reconsideration is part of the pleadings or part of the record here. And I went into some detail about property versus premises. And, but again, we get down to what was the bargain that the parties had entered into. And clearly, right from the get-go, the buyer was concerned about being able to keep chickens on the property. And the offer, the contract to purchase, the initial offer did not make any mention of lot 26. It was just lot 2.
But
so it's
what
clear.
you're doing when you do that, counsel, is, and I think this is also what Judge Kinder was getting at, you're asking us essentially to read the history of the parties' negotiations into the language of the purchase and sale agreement. But the purchase and sale agreement has a full integration clause, right? So we
Yes.
have to start by looking at the purchase and sale agreement, right? And there we have this word property. And your argument basically is the word property that's used in that ultimate clause is not the same thing as the word premises in paragraph 2. But on the face of the agreement, what would tell us that?
Well, the paragraph 27B may be somewhat inartfully drawn, but that's what came in. And again, the intention of the parties, the understanding of the parties was they needed to be able to keep chickens on the lot. Now, maybe the question isn't really that significant because, in fact, lot 26 is not encumbered by any prohibition against keeping chickens. And I'm happy to go there if you want.
Wait, so, oh no, that's a different argument. I thought you were going to make the argument that lot 2 isn't.
Well, it's.
I have to say, I looked at this and I came away with a very different view than both of you had articulated, and that's probably, I probably should put it out there, which is the contingency says that it's subject to a title search by the buyer's attorney confirming that barnyard animals may be housed, stabled on the property. And the title search showed without doubt that they could house and stable on the property. Not the entire property, but certainly 8.1 acres of it. But that leads me to a different problem, which is there's another contingency which says, and the property has no covenants or restrictions. Now, why isn't this, I mean, leaving aside for a moment your argument, which is that lot 26 is not in fact encumbered. If lot 26 were encumbered, why isn't that a covenant or restriction on the property? You get, we're back to the same argument, right? Which is the property doesn't include the road.
Well, no, I think the, again, while that phrase may be inartful, and I may be bumping up against the same problem as to what was the intention of the parties, I think really what the contingency was intended to be was that there are no restrictions or covenants prohibiting the keeping of animals on the property.
That's not
Now,
what
that's not what it says. I understand that. But again, I think what the parties, what led up to this can be looked at to elucidate what the parties were thinking. Because again, if you recall, the agent for the buyer, before they even made an offer, asked that there be a certification that there are no covenants or restrictions prohibiting the chickens on the property. And that is the case. I mean, it also makes rational sense because the attorney doing the title search is not going to find a document on record that says, yes, you can keep chickens on the property. The point is, are there any prohibitions or restrictions about keeping chickens on the property that are on record? And there are none relative to lot 2, and I don't think there are any relative to lot 26 either. So the benefit of the bargain here is—
Can you articulate what your, as I understand it, and I have to confess, I am not an expert in reading the title for registered land, and perhaps I'm going to have to become one. But as I understand it, the restriction with respect to the use of barnyard or the keeping of barnyard animals appears on the title itself for lot 26, because it refers back, doesn't it?
No, it does not. And Judge Karp made that same error. Now, the original protective covenants were document, 308-104. And 308-104 is listed as an encumbrance on the certificate of title for lot 26.
So why isn't that the end of the story?
No, you have to look at the document. You have to read the document. You can't just, because it says protective covenants. You don't know what it's protecting unless you read the document. And when you read the document,
you mean 308, the original 308.
Right.
So that's listed. If you look at lot 26, you got a list for the for 308-154. And you're saying when I look at that, I'm going to conclude that it's not a restriction on lot 26 because?
Because it specifies what lots. It specifies lot 14 on the D plan. And I don't know if your honors recognize registered land. Every time you subdivide something, you go from the A plan to the B plan to the C plan, and the lot numbers keep going up. They don't repeat them. So the D plan, it listed lot 14 as being protected or prohibited. And it also listed lots 18, 19, 21, and I think 22 as being.
Isn't lot 26 is subsequently created? So what
Correct.
was lot 26 subsequently created out of any of the lots that you just identified in that list?
No,
No?
I don't believe
was.
so. So, but I think the other thing to
Well,
understand.
Well, I mean, it seems to me, well, at least to me, that seems very important. If you have a restriction on a predecessor lot to lot 26, of course, it's not referenced there. It didn't exist yet, but but lot 26 is actually created from one of those lots on the list. That seems to me to be significant. Are you telling me when I look that I'm going to find that none of those lots that are listed encompassed lot 26 before it was created?
Correct.
Okay.
The
Let me ask you a different question, Mr. Caffrey, related
Yes.
to that point. And that is, let's assume that you're right about that. Why doesn't the other covenant and restriction having to do with the access road also apply here? Now, I know that you've argued that that was not initially raised and therefore waived. But as a matter of law, we can make a decision based on anything that appears within the record. And I guess my question is, putting aside all of this argument about what property means, why isn't your position defeated by that second covenant?
Well, again, I think to some extent it goes back to the early argument that what was the intention of the parties and what was the bargain. And the bargain was that there were no covenants or restrictions which prohibited poultry on lot 2. And that is the case. Now, again, it was inartfully drawn in retrospect, no covenants or restrictions. But again, it makes no sense to say that the buyer's attorney is going to do a title search to confirm that barnyard animals can be kept. What they were doing was a search to make sure they can't be prohibited.
But that's a separate issue from the covenant restricting the access road.
Well, not really, because the intent of those words was not that the land had no covenants or restrictions. The intent was that there were no covenants or restrictions relative to animals.
In your brief, one of the things you say is that the judge's decision created a windfall for the plaintiffs. And it wasn't clear to me how that would be possible if the end result is they don't have the property, nor do they have their $97,500.
My
Why isn't
client
that a
had
windfall for your client?
Well, the agreement was that if they defaulted, that the money would go to my client. He had the property off the market for all that time, and as a matter of fact, lost the market, and it was another 2 years before he sold the house. But they were not entitled to get their money back. They had bargained to be able to keep chickens on lot 2. They could do that, and to be able to keep the property off the market and walk away with their deposit is a windfall for them.
Attorney
I mean,
Caffrey,
maybe windfall is not the right word, but
Attorney Caffrey, let me ask you this question. When the language is clear, how do we get to the intent of the party? So I take it that this contract or purchase and sales was drafted by your client, correct?
the initial contract to purchase was done by the buyer's agent, I believe, and that created the initial contingency.
And the language there is clear and broad.
Well,
How do we get from there to saying, but look what we really meant?
well, I don't think that's necessarily the case, because if the contingency said the premises, I think that argument might hold, but the contingency says property, and the section 2 calls it the premises. So I think,
But it
you know,
says it doesn't limit it, and I'm sorry, I'm not clear. It doesn't limit it to barnyard animals. It says covenants and encumbrances, correct? Now you say, but really look what we meant about it. How do we get to that second level of analysis when the language is clear and unambiguous?
I think you do because there is a disagreement over it. And I think it is ambiguous as to what is meant by those words. And again, they didn't raise any objection as to covenants or restrictions. And I think that goes to their understanding of it also. They didn't raise that with the withdrawal.
Well, they raised
order.
one covenant or restriction. They raised the covenant or restriction that had to do with barnyard animals on the road.
Right, but they were wrong with that. They're just flat wrong. It does not encumber the property.
Okay.
All right, Mr. Caffrey, I see your time is up and I see no further questions. Attorney Buhmiller, you may proceed.
Good morning, Justices. May it please the court. May I first ask if I'm being heard?
We can hear you.
Thank you. My name is Donald Buhmiller. I represent the plaintiff appellees, Jessica A. Grigg and Jen C. Schoenberg. Let me get right to the point. Clearly, you've understood and grasped the issues here. By way of background, in the summary judgment record, the defendant agreed that the contract recited within it all the rights and obligations that the plaintiffs and defendant bargained for with regards to its subject matter. Attorney Caffrey overlooked that. He also overlooked the fact that in that offer to purchase, I believe it was clause 13 states that once a purchase and sale agreement is entered into, anything contained in the offer to purchase is out the window. Doesn't have any legal effect whatsoever.
Mr. Buhmiller, let me ask you this.
Yes, Your Honor.
As a practical matter, understanding that chickens and other barnyard animals would not be raised on lot 26 because that was the access road, and that you could continue to raise barnyard animals on lot 2, which was the residential lot. Why terminate the contract?
Number one, the clear language of the contract gave them the right to do so.
Yeah, well,
And
as a
I'll rely
practical
on
matter,
that,
not as a
but
legal matter.
Behind that, there's other issues, Your Honor. Town of Boxford has minimum 2-acre lot zoning. People cherish their privacy, they cherish quiet, they cherish peace. Chickens make a lot of noise. And this property, lot 2, was grafted onto a larger subdivision in which all the residential lots prohibited the keeping of chickens and barnyard animals for the peace and quiet of those residents. And my clients, as they made clear from the start, did not want to purchase a piece of property where they would anger and alienate and not make their neighbors happy because they alone had this lot that made a lot of noise with their chickens. Have I answered that question, Your Honor?
Well, I understand that was your reason. Let me ask you another question. Mr. Caffrey has made the argument to us that the barnyard restriction or covenant does not apply to number 26, lot number 26. And I'm looking now at the certificate of registered land, which does specifically refer to lot 14 and lots 18 through 22. Can you enlighten us as to whether or not it applies to lot 26?
Yes, and by way of background, when I first argued summary judgment, I relied on the fact that the buyer's attorney certified that lot 26 prohibited the keeping of those animals. The attorney's certificate was done in, that certification was done in good faith. At summary judgment, Judge Karp said, well, how do I know that it's really encumbered? That I think was an extra level that wasn't required. Then I went to the registry, I copied the restrictions, they're on record. For
I'm-
registered land, those encumbrances are there, and it says that no barnyard animals or chickens may be kept on lot 26.
No,
Right
it
on the
doesn't
record.
say on lot 26, does it?
Yes,
It says on the certificate for lot 26, it says the restrictions of some other document that you got to go to, doesn't it?
yeah, but yes, Your Honor, but the statute says if that restriction is there on the record, you can rely on it. That's the
Well,
plain
but the
term.
restriction doesn't say, if you go and read it, as Attorney Caffrey points out, you go and read it, it doesn't identify lot 26, which leads me to this question. Is lot 26 subsumed within the area of any of the lots that are identified on that certificate?
Yes, it started off as one piece of land, and Leclerc's predecessor chopped it up into different lots for housing.
So which lot was lot 26 a part of? Which of the lots identified in the certificate was lot 26 a part of before it was created?
I think it was lot 23,
23, but 23 isn't on the list either, is it?
but it's on the certificate of encumbrances.
Well, there's a certificate of encumbrances, which you have to go read to find out what the encumbrances are, don't you?
No, it's there. And that,
Well, I mean,
Justice,
what, I'm sorry, I don't have the document in front of me. Possibly Judge Kinder does, but this is my understanding. My understanding is the document says something like encumbrances, see document 308 blank, blank, blank. Isn't that what it says?
yes, basically.
Okay, well then that doesn't on its face tell me anything about what the encumbrance is. I got to go read the document.
No, you go to the certificate of title, you look at the encumbrances, and there it is. It's right there on the encumbrances.
I'll
Well,
read it.
let me stop you there, Mr. Buemiller, because I happen to be on that page of the record. It's 139 of the record appendix,
Okay,
which is that list of all the entries on the registered land. And the third one down says in favor of Michael J. Kenny, protective covenants, lot 14 and lots 18 to 22. So the question I think we're talking around is, how do we get from that to lot 26?
we do. It's there on the encumbrances.
Wow. That's not
Other than
particularly
that,
powerful to me. I gotta tell you,
No, let me go a little bit deeper. I've got 8 minutes left. There was the predecessor in title removed some restrictions from part of the land, but he didn't remove the restrictions on the lots that lot 26 was created from. More importantly, in his denial of Mr. Caffrey's motion for reconsideration, Judge Karp correctly noted that if there is any question about whether or not the encumbrances on the certificate of title for lot 26 had any ambiguity in them, then the proper thing for Leclerc to do would be to go back to the land court and petition to have that removed. Said that was the way to do it, not as a defense to this action. That's correct.
If there was ambiguity.
Because the statute clearly states that my clients could rely on the encumbrances that appear on record, and they appear on record. And that's the plain language of the statute, Your Honor.
Judge Kinder, do you got anything more on this subject?
No, you can feel free to move on to the next.
So in his brief, your brother argues that even if there were a breach of the conditions, it's not a material breach, such as to allow your clients to avoid the contract. what do you say to that? Because you didn't address it in your brief.
Well, I think I did. There's an integration clause that says this is the contract. What we have here is the contract.
Doesn't the breach still have to be material in order for you to use it to avoid the contract entirely?
Well, what can be more material than paragraph 27B saying that if the property has any covenants or restrictions, my clients can get out of this deal and get their $97,500 back. The contract made it material, Your Honor.
So you're now relying entirely on the clause that says property has no covenants and restrictions.
No, I'm not. No, that's not
Well,
true.
because the other clause says, I have to tell you, I don't see how it was breached at all. Buyer's attorney confirming that barnyard animals, including poultry, may be housed, stabled on the property. Isn't that exactly what he confirmed? Barnyard animals can be housed and stabled on 8.1 acres of the property.
But that's not the property being sold. That's part of the property being sold, but the property being sold is lot 2 and lot 26.
You want to insert the word entire before the word property into that clause.
No, I don't. I rely on every word that's in that contract and nothing more.
Okay. I have to tell you, I read it completely differently. But there is this other clause, which is the clause that you went to when you were arguing, which is one that says property has no covenants and restrictions. And you say, well, it does have covenants and restrictions, and we made it material, and that's material enough to avoid the contract. That's your argument, right?
My argument is that we rely on the plain, unambiguous terms of this contract.
Okay.
And what's your response, Mr. Buemiller, to Mr. Caffrey's argument that at least with respect to that second part of 27B, that is any covenants or restrictions, that specific argument was not raised and therefore waived?
I think that's addressed in the Prozinski case, where that case says that in an employment termination contract, once you get into litigation, the employer is allowed to rely on reasons for termination that weren't expressed in the original termination letter. I think that applies here.
Except that the clause says on or before April 12th, 2018. Why isn't a reasonable construction of that any objections that came out of a title search needed to be made by April 12th? And if they were not made by April 12th, then they're not made.
Well, they did make it. They didn't say the other reasons, but I don't think that clause 27B requires them to state all the reasons. And the reason they stated, by the way, was sufficient. The certificate of title encumbered lot 26 against the keeping of the chickens and barnyard animals. I have about 3 minutes left. May I state something about Justice Cass? We both relied on decisions by him. He recently passed away. Both of us, Mr. Caffrey and I, relied on the Bendison opinion. And in his obituary in the Boston Globe, Justice Obel remarked about the way that Justice Cass would write with eloquence, with humor, with wit, and would not make either party feel bad. And in that Bendison opinion, there was one phrase that kept sticking in my mind: faced with an integration clause. In that case, the losing party was faced with an integration clause, as we have in this contract. And faced with an integration clause, the defendant here denies that an encumbrance on the record title for lot 26 shouldn't exist, even though it does. Faced with an integration clause, the defendant asks you to look to the intent of the parties rather than the language of the contract. Justice Cass was a wonderful person, and that one phrase keeps coming to my mind: faced with an integration clause. And that, I think, is the key here. This contract contained the entire agreement, and the plaintiffs were completely justified in getting back their deposit.
Thank you, Mr. Buemiller.
Thank you,
Go ahead.
Justice.
Have you completed your argument?
I believe I have.
All right. I see no further questions, and let me just say, counsel, we share your fond memories of Justice Cass, and it was an excellent way to end your argument.
Thank you.
I want to thank you both for good argument.
And we're live and on the record.
Thank you. Welcome to this morning's sessions of the Massachusetts Appeals Court. This is January 7th, 2022. The next case on our docket is 2020 P1094, Board of Health of the Town of West Springfield versus Daniel Bushy and others. And let me turn first to you, Mr. Marshall, and start with a question right off the bat. As you know, Mr. Schneiderman has filed a motion to dismiss, suggesting that we lack jurisdiction because there was not a timely notice of appeal. None of us saw any response to that. So I wanted to give you an opportunity to respond at the outset of your argument. You may proceed.
Thank you, members of the panel. May it please the court. In this case, we were waiting for the decision of the Western Division Housing Court on the motion. We felt that the motion, the decision that did render, didn't address all aspects of the motion that was under question. And quite frankly, my client just needed the time, was looking to make an informed decision about, because this case was ongoing, this was a motion that would be heard that was not dispositive of the entire case.
Why was it not dispositive of the entire case?
Well, it was dispositive of the question of my client's lien at that time, that there would be additional costs if we weren't able to auction, we thought because of moratorium that may have been in effect at the time, that we didn't want to be in contravention of the judge's order, scheduling something we couldn't. So we were looking for clarification. If we weren't allowed to auction at that time and it ended up going out considerably, there'd be considerable more cost for management of the property, utilities. Unfortunately, my client, even to this day, is still in legal possession of the property, so there have been additional costs anyway.
So you'll have to forgive me, counsel, because I'm not particularly familiar with the process that you were involved in. Your brother says the order of July 3rd was dispositive of everything that was left in the case. You say no, and that obviously is darn important to this issue. The case is brought initially by the Board of Health against Attorney Schneiderman's clients, and then a receiver is appointed. What is the relief that's initially sought by the Board of Health? It's sort of a condemnation of the property. Is that what it is? A declaration or something that the property is in violation of sanitary codes?
Well, when the town brings this complaint before the housing court, in its petition, it is asking first for the housing court to make a determination that in fact, this building, the structure is some type of hazard, either to current occupants or future occupants. So that's part of it. That also the town is asking for a determination that the current owners, as far as ascertained, do not seem willing or able to get this property up to code. And then after those two determinations, if they are both made by the housing court, to then appoint the receiver to bring that property into compliance with
So
the
all
town.
of those things had occurred by July 3rd of 2020, hadn't they? All those determinations. What is left to be done? You say what's left to be done is to place the property for auction?
What would be left to be done from the receiver's perspective is to, generally, the practice is to put it up for auction in order for the receiver to be able to satisfy its lien as established by the housing court. In this particular case, another option is for the house to be listed for sale.
Let
I
me
would say
interrupt for a
Mr. Mullin.
moment, Attorney Marshall. I'm not sure I understand your response to the question of why are we addressing this matter when your appeal was filed late?
The appeal, what we were asking is that, in a sense, is for the motion for clarification to allow us, because we believe we needed information that would be forthcoming from that motion for clarification from the court. I was unable to find case law here in Massachusetts that's directly on point is addressing a motion for clarification. Certainly motions for relief from judgment would, some are clearly
Right, but
spelled
the
out.
motions for relief from judgment have to be filed within 10 days. Your motion for clarification was not filed within 10 days, right?
Yes, sir.
So under the, if the July 3rd order is an appealable order, how is it that we can fit it within the notion that you have a timely appeal of that order, right? It was docketed on July 3rd. There's no motion within 10 days. The notice of appeal is 47 days after the order was docketed. So that's why I was asking questions about whether it's an appeal, essentially going to the question whether it's an appealable order, because I thought I heard you saying there was still more to be done. So it's not, the judge was not done to the point where the order should be considered an appealable order. That's what I thought your answer was.
No, as far as the judge's decision, which we were appealing, was a decision on a motion. It was not the end of the receivership. I'm sorry. I believe that's what you were referring to. The case itself is still open.
What's the case open for? So I noticed that on page 10 of her order, she says the receiver is authorized to sell the property at auction to satisfy its lien in the amount approved herein. That seems to me to be a pretty clear directive that you can do that. Why is the case still open? What's left to be done?
There would be a final lien of the receiver because there were, even up to the point that the decision issued, there had been further expenses incurred by the receiver. Another future expense would be whatever the cost of either auctioning the property or marketing the property, the fees to realtors, et cetera.
So why not do that and then take your appeal from the final order with the final lien amount?
That I guess was part of the discussions that we had with our client. I do appreciate that the motion for clarification was outside of the 10 days. It would be for a motion to amend the judgment.
Are there any cases on what is the final appealable order in the context of a receivership like this? Is there any case law that we can look at that you're aware of?
I'm not aware of it. Perhaps Attorney Schneiderman. I don't believe he referenced any in his brief. If he's aware of any, I'm not.
Okay. Want to go and address the merits of your argument?
Would, Your Honor. Rather, please. So in the course of dealing with the Western Division Housing Court, my client has had many receiverships. In all of these receiverships, my client acts as more a management company. It hires a Nick's Affordable Home Improvement, which is more a general contractor, and then Nick's Affordable Home Improvement handles the repairs or arranges to have those done. Been doing this by the same process for a number of years through at least 10 receiverships. So in this case, in accordance with the usual practice, after my client was appointed as receiver for the property, to turn to the construction contractor used, Nick's Affordable Home Improvement, to formulate the rehabilitation plan for the premises. It's broken down by line. It's one of the exhibits included with the brief, with a line item, which is a figure, an estimate for that phase of construction, say flooring, bathroom renovations, etc., with the estimated price from Nick's Affordable Home Improvement. That plan was submitted. It was approved by the Western Division Housing Court, and in fact, once all of the construction phases project was done, it came in actually under budget of what was originally estimated.
But doesn't the judge have independently and part of her role is to look at the expenses that are provided and determine whether or not they're reasonable? Isn't that part of her role? What's our standard of review?
I would suggest that the standard of review would be de novo, only because the court below is not making any credibility determination. It's not even assessing any expert. It was uncontested, really. There were no experts brought by the appellees.
Why isn't she making credibility determinations as to whether the costs are reasonable and actually incurred? Isn't that part of what she's?
But in the decision, Judge Fine did note that there was no impropriety, that all of the work that was listed in the rehabilitation plan was completed, that it was certainly
comfortable that the work was done, but does that mean that she's comfortable that the work was worth $175,000? And I mean, she held a lengthy hearing where she heard from a lot of people about this subject, and she asked your client more than once, I think, to go back and give her better information about a breakdown of the costs and expenses, didn't she?
She did. And
are you telling us that that was an abuse of her discretion to say, I really want to understand better how these costs were incurred?
The abuse of discretion that we allege would be when the court in the decision, I mean, it's clearly referring to and relying upon guidelines which the court had itself had promulgated regarding receiverships, and one section of which explains directly what type of documentation is expected. Again, my client had been handling receiverships in front of this court for a number of years, a number of times. The same documentation that we provided.
Had anyone ever challenged it before? Had anyone ever challenged it before the way that these homeowners did challenge it? I'm assuming the answer to that is no. You were caught by surprise. Someone challenged the quality of the underlying information, and the judge then had to make a decision about whether the information that had been provided was sufficient to justify the lien, didn't she?
I would say in the past, certainly there have been situations where homeowners have shown up, have questioned it. This is the first time, to the best of my knowledge, that an evidentiary hearing was held on that, asking for the additional documentation. Usually, in all cases in the past that I've been involved in, the court, again, refers to the handbook. It's always been showing the court, helping the court to understand what the arrangement was and what provisions of the documentation requirements in the receivership handbook are applicable. In this case, here, months and months after the repairs had been done, the judge certainly absolutely gave us the opportunity to, on a couple of occasions, provide additional documentation. So we went to the general contractor, Nick's Affordable Home Improvement, and asked them for a breakdown. We had no control over, I guess, what they provided to us, which was the same invoice for work they had done.
I don't understand that. I don't understand that. You're the receiver. You've been appointed. How is it you don't have control over what documents you receive from the person you've hired to do the work?
It's because really in the course of business with this other company over a number of years, they submit an estimate at the very beginning of the process for each phase of the work that was brought up in the health department report. They complete that work. In this case, they completed them under budget, and then they're paid from the invoice that they submit to my client.
I think Judge Fine is saying, hey, that's not enough. Okay.
We realize now, I surely would.
Thank you, Mr. Marshall. I see your time has expired. Mr. Schneiderman, you may proceed when you are ready.
Thank you, Your Honor. May it please the court, I am Joseph Schneiderman. I represent Anthony Curto and Judy LaBelle. I'd like to start by answering some of Justice Englander's questions. First, General Laws, Chapter 111, Section 127I, which is discussed at some length at pages 23 and 24 of the brief, talks about when and whether a receivership is proper, and the standard to appoint a receiver is that the sanitary code violations will not promptly be remedied such that appointment is in the best interests of the occupants residing in the property, and a receiver shall promptly repair the property and maintain it in a safe and healthful condition. In practical terms, a receiver is very much, as is otherwise established as an equitable remedy, a last resort. There are enforcement actions. The record of this case, particularly West Springfield's petitions for enforcement, which are reproduced in the supplemental appendix, go through how there is a history of code violations at 85 Adrian Avenue. West Springfield attempted to obtain compliance, and then finally in 2018.
All right, I get that part.
Mm-hmm.
Let me ask you this.
Sure.
Is he right that there's still proceedings that have to take place? I shouldn't say it that way. Is your brother right that there are still proceedings that need to take place in connection with the receivership, and that the case is not closed?
Your Honor, I am honestly not sure what other proceedings there could be, but
he suggests that if they sell the property, that they're going to have to go back and have the lien adjusted to reflect the cost of the sale.
Actually, Your Honor, that's something I wanted to answer, which is an order in the course of a receivership directing the sale of property is appealable. That is the SJC's decision in Colombo, which is in the September 22nd, 2021 16L letter.
So directing the sale of, is that what you think this order is?
In practical, I'm sorry, Your Honor, I didn't mean to interrupt.
No, that's all right. So you cited that case in your brief, didn't you?
Not in the brief, Your Honor. I apologize. I brought it to the court's attention in the 16L letter.
Okay, I remember that. Okay. So that might be one answer, because as I think everyone agrees, this is not something that says judgment. This is something that says order. Mm-hmm. And so then we have the problem of, is that an appealable order? And your brother says, well, there's more that's left to be done, which ordinarily, if there's more that's left to be done, you wouldn't call the order appealable. You'd wait until everything was finished, unless there's some case out there or some reason to treat this particular order as appealable, and you're saying we're going to find a case that says it is.
The closest I can see, Your Honor, is the Columba case, saying that an order of directing the sale of property in a receivership proceeding is immediately appealable. The site is 447 Mass 1005. And I think in any event, if this isn't a final judgment, then this is the first time I've heard that suggestion that this isn't
Well, he didn't respond. He didn't respond to your brief until he got here. I mean, we have to decide. You raised this as a jurisdictional question, so we have to decide it, and we appreciate you raising it as a jurisdictional question. It was correct to raise it. If in fact we decide that we don't have jurisdiction, where does that leave you? That just means it's unappealable, and that leaves us with the possibility that it becomes appealable at some time in the future. No?
Your Honor, I'm sorry. I keep interrupting.
Your position is that it is appealable. All right. In that case, they've missed their chance. All right.
That's correct, Your Honor. Yes. Even if this is premature, if we give my brother every benefit of the doubt, I think the court would. There is case law also suggesting that from a procedural perspective, the failure to enter a judgment or the fact that it is premature can give an appellate court discretion to address this issue, and it's up to the court as to whether or not you would want to exercise your discretion to decide this issue. So if it's 180 degrees the other way, which is to say this is not in fact a final order, I think judicial economy might be served by addressing this order on the merits. But I stand by my point, which is that this is an appealable final order. I think Your Honor's actually covered much of what I wanted to say here, which is Orange Park did not appeal within 30 days. The substance of Orange Park's order or motion does not question the underlying correctness of the judgment itself. We always look to the substance of those orders since the SJC's decision in Pentucket Manor in 1985. They have not alleged any cause to excuse this failure. The question that they raised was, could they auction in light of the eviction moratorium? That does not challenge the underlying substantive correctness of the judgment. It questions how to implement the judgment. We always look to form over, I'm sorry, that's backwards. We always look to substance over form, and the substance of the motion does not bring that up. The concerns that underlie this provision of Rule 4 saying a motion for reconsideration stops the clock or causes an appeal to self-destruct are not really implicated by this record, because there isn't a prospect that a trial court and an appellate court could modify the same judgment at the same time. So I think in the end, this was a final appealable order on July 3rd because all claims against all parties had been disposed of, and the only thing left to do was to execute and foreclose on the lien. And if it's 180 degrees the other way that this is premature, then the court should exercise discretion to address the merits anyway. I would just note on that generally an appellant is stopped from disclaiming the prematurity of their own appeal. That's Brown versus Quinn, an SJC decision. I don't remember the site off the top of my head, but it's from 1989.
So what is the standard of review? He says de novo.
Your Honor, I would agree that it would be de novo if it were purely based on documentary evidence, but that is just not what happened here. Judge Fine held a lengthy hearing, heard from witnesses, indeed witnesses who admitted that they did not engage in this sort of record keeping. That's at transcript 130 to 143, especially 134, 135, 6, 7, and 8. Judge Fine had every right to make credibility determinations, and in essence, she did. She made her decision based not just on the cold record, but based on the outcome of the hearing. The other inquiry is the amount of the costs is a holistic inquiry, much like the amount of attorney's fees, which is reviewable for an abuse of discretion, which the SJC reaffirmed as recently as 2020. The standard of review,
again, the amount of the costs, much like attorney's fees, is reviewable for abuse of discretion. What case says that?
Your Honor, that is at page 47 into 48 of our brief. That's Blake versus Hometown America Communities, 486 Mass 268, 284 to 285. And indeed, cited earlier on page 47, in 1869, the SJC recognized that courts do not regulate the compensation of their officers based on a fixed commission based upon the amount of money passing through their hands, but such amount as would be reasonable for the services required of and rendered by a person of ordinary ability.
You're arguing by analogy from Blake, which is about attorney's fees. You don't have a case talking about receivers' costs that says that it's abuse of discretion.
Your Honor, I'm not aware, I hadn't seen a case that specifically said that, but I think if one reads Blake and Grant harmoniously, and in light of the nature of what Judge Fine did here, I think the standard of review is an abuse of discretion. Perhaps it would be helpful for the court to articulate that in this opinion. Moving a bit into the merits, actually, Your Honor, Justice Englander, I think hit the nail on.
You'd like to write it, you know.
I beg your pardon?
I'm just kidding. Sorry. You were writing the opinion for us there, I heard.
I would welcome that, Your Honor. I thank you.
I'm sure you would. I'm sure you would.
Your Honor, actually, I think got to another of my main points, which is Orange Park, even if they may have had a history of doing these receiverships in the housing court, had at least 4 warnings to provide the complete and accurate documentation that Section 127I requires. I would note that 127I is written in mandatory language, particularly the last clause of 127I, detailing a receiver's obligations to provide status reports and to provide documentation to the court. And indeed, the record reflects that Orange Park was not as assiduous as they should have been. There is a status report in February of 2019, which is 4 months after the order appointing them as the receiver. There is a status report in September of 2019, and the work is broken down in receipts and invoices after that. And
memory, as you point out, that the statute explicitly says that if the court asks for more information, need to provide the additional information, right?
That's absolutely correct, Your Honor. At page 49 of the brief, that walks through that. The handbook even walks through that and says if there is a question of deficient documentation raised either by the town or the city or by the court, the receiver should provide that information. So Orange Park wasn't ambushed by this. I think to suggest that they were ambushed by this does not comport with the record. There was an objection to the lien, which is at supplemental appendix 93 to 96. Judge Fine opens the hearing by saying, I am concerned in light of my consultations with Assistant Clerk Magistrate Castillo. There was Pavlo Yasenko's testimony about what documentation is kept. That's at transcript 130 to 143. Transcript 144, the court articulates concern again. Transcript 157, Mr. Yasenko says we don't question bills. And at the very end of the hearing at transcript 175, Judge Fine says, I'll give you 2 weeks to submit additional documents. And none of that ever happened. The sum purpose of 127I and of why the need for this documentation is compelling is because receivers must be accountable to the court, particularly whereas here a receiver is depriving a person of dilapidated property that potentially poses a public health and safety risk. And Judge Fine, I agree with my brother, Judge Fine disclaimed any finding of impropriety here, but impropriety is ultimately legally irrelevant. It's up to the receiver to show their work, and they did not do that. Very briefly about the handbook, I would just say the handbook does not have the force of law. It is not promulgated as a standing order. Yes, it may be a helpful interpretive guide by practitioners in the Western Housing Court to fill a gap because 127I is silent, but any interpretation of 127I must further its purpose, or silence on an issue must further its purpose. To the extent there is some intractable collision, which I think the court doesn't need to reach that. I think the handbook and 127I can be harmonized. But if there is an intractable collision, 127I must prevail over the handbook. And I think the suggestion that the handbook governs or has such force just is not sound. And there's no suggestion it has agency deference. There's too much reliance on the handbook here. I see my time is running out. Unless your honors have further questions, I ask either that the appeal be dismissed or that the court affirm the amount of the lien.
Justice Englander, anything further? And I see nothing from Judge Walsh. Thank you very much. Your arguments have been helpful. We'll take the matter under advisement.